Hello, all. Welcome to another session of Legal Essentials for Human Resource Management, a one of a kind course that tries to bring in HR functions and label all together and tries to build a legal acumen for HR managers. So if you remember our last session, we were largely discussing about key definitions in the CLRA Act, and we looked at what are some key terms and its definitions that you should be aware of when you are dealing with contract labor. Now, with that knowledge, let's move into session 15 of this course, where we would be discussing about what are the various duties and obligations an employer as well as contractor has under this CLRA Act. And without much delay, let's get into today's session. And as you may be aware, my name is Dr. Amish Samaloparan. Now, to begin everything, we should have a clear understanding about what is the difference between a normal employee and a contract worker. So if you look at a normal employee, he works directly under the control and the supervision of the employer. So if you remember, in our last class we discussed that if a worker is directly working under the contractor and reports to him, he may not be called as a contract worker. Reason being, if you're working directly under somebody, you are an employee of that person. So employees work directly under the supervision of the employer, whereas contract workers are not directly employed by the principal employer, and they are engaged through a contractor to perform specific tasks and services. If you remember the examples that we are discussing, I have a IT company. I want somebody to cook food for my employees. I have approached a contractor. So the contractor is bringing in certain employees and specifically for cooking food. And they report to their contractor. I don't know from where they are hired. I don't know probably their names also at top of my head. But they work for me through contractors. So such workers are called as contract workers. Now, another difference is that the employer has the authority to direct and control the employee's work, his working conditions, working hours, as well as wages and other social security benefits. Now, employer is everything and anything for an employee. There is no other boss in the picture at all, right from hiring, payment of wages, ensuring social security provisions are provided, firing the employee. All these things are under the employer for an employee. Now, when it comes to contract worker, the contractor is responsible for recruitment, employing him or her into various tasks, and payment of wages, and ensuring that various social security provisions for the contract workers are met. So major differences are two. One, a regular employee reports directly to the employer. A contract worker reports to his contractor. And second is that all the social security provisions, wages, recruitment, all those factors are taken care by the employer when it's a normal employee. But if it is a contract worker, it's the contractor who takes care of all those factors. And third defining feature is that employees are integral to the core operations of the employer's business. He is directly involved. So in management term, we call it as technical core. So employees are the technical core on which the entire organization is built. But contract workers are often hired for a specific task or services, not even integral to the technical core of the work of the organization. So that's a difference between employee and contract worker. I would like to discuss an interesting case at this juncture that will make it clear regarding how the relationship between employer and a contract worker happens. So, International Airport Authority of India, I mean, the airports were under them, and there was cargo handling. For the cargo handling, they had hired people through a contractor. So, it was an air freight company who were handling the ground activities. Now, International Airport Authority of India decided to take over the ground handling work. So the employers, the workers who were working with the air freight started saying, see, listen, we were doing this job. You were telling us what has to be done, as in the International Airport Authority was telling us what to do. Disciplinary actions on us was also being taken by you. Now that you're taking over, we also as employees are part of you. No, we are not contract workers anymore. So the Air Cargo Workers Union was fighting this case, and it went to the Supreme Court. And Supreme Court clearly said that, you know what, International Airport Authority of India and between the workers, there was no proof of direct payment. So the biggest thing is that if you look at the difference between employees and contract workers, you will say that wages are paid for employees by directly by the employer, but when it comes to contract workers, wage is paid through the contractor. The primary employer might give a lump sum amount or a in a various various quarters they might be paying the money, but the payment of wage is done by the contractor. Now, the court couldn't see any proof of which direct payment has happened. Disciplinary actions have been taken directly. Court said that just because disciplinary actions are taken directly, it is not direct employment. And somewhere around it boils down to the fact who is paying the wages. So, contractor is paying the wages means there's a clear established relationship that the person is a contractual employee. Now let's look into certain duties and obligations of contractor as well as employer when they have to hire a contract worker. So the first duty is regarding registration of establishment. So if you remember my discussion in the last class, we have decided, or rather we have discussed what is an establishment. So imagine you have an establishment, you are an employer and you intend to hire contract employees. The first thing is that the principal employer of any establishment have to register the establishment under the registering officer, and once the registration procedure is started, the registering officer shall proceed to register the establishment and issue a certificate of registration to the principal employer. So it becomes the duty of the principal employer to initiate the proceedings of registering their establishment, and once it starts, the registering officer would proceed and then issue a certificate of registration. Only if you have this registration, you can go ahead and have contract workers. So any contractor who meets the threshold needs to have a license from the appropriate government to undertake or execute any work through contract labor. So if you are a principal employer, you have to have registration of your establishment, and if you are a contractor, you should also need to register and have a license from the appropriate government to execute any work through contract labor. You can't just walk around and then pick 20 people and then walk anywhere and say that I'm a contractor. You need to have proper license. Now, what is the liability of a principal employer? Let's say contractor fails to provide the required amenities, could be a canteen, a restroom, or water, washroom, first aid facilities, or even wages, the contractor is not paying. Thus, the liability falls with the principal employer. See, I have a hospital and I have paid my share to my contractor or even a fraction of it in the initial, but the contractor is not paying the work amount money, the wages to my contract workers. Am I liable? The answer is yes. It becomes the responsibility of the principal employer to ensure that, let it be any of the benefits or amenities, that has to be provided statutorily. If it is not being provided by the contractor, principal employer has to ensure that that is provided. There's a catch. Principal employer now has the right to recover all the expenses incurred while providing such amenity from the contractor. So the best thing is that you don't pay all the money upfront. So outstanding payment, you can deduct the amount or carry over to the next year, or a debt. It will become a debt which you can challenge that they have to pay back. So make no mistake, you cannot escape the obligation as an employer even if you have hired the workers through a contractor. You have to step in, ensure that all the amenities as well as benefits are provided, but of course you can take off all that money later from the contractor. Under the ESA Act, we'll discuss ESA Act a little detail while we discuss social security from the next week. So according to ESA Act, a principal employer has the duty to make contributions on the first instance. So the first instance of the payment of an employee share should come from the principal employer. So that obligation also principal employer has. When it comes to Provident Fund, PF, another social security benefit that workers are provided, we'll also discuss PF in the subsequent classes, next classes, where the discussion would be on social security provisions. So let's say the contractor is not paying the Provident Fund money, the principal employer has the liability to pay that share also. Now let's look at specifically the wage part. The contractor has to pay the wage, no questions asked. And Payment of Wages Act, while we are discussing, we told you that there is specific timelines. So if you are daily wage, the money has to be paid at the end of the day. If it is weekly, it has to be paid the last working day of the week. And if it is monthly, 7 days, after the 7 days after the period of work is over. And if it's a bigger organization, then 10 days. So clearly the dates within which the payment has to be made is well defined under Payment of Wages Act, which we have discussed in the last week. Now let's say the contractor failed to pay the money within the stipulated time. What will the principal employer do? So let me explain what are some of the responsibility of the principal employer while paying of wages. First thing the principal employer has to do is that a representative of the principal employer has to be there while wages are given by the contractor. Now this the act itself says. You cannot blindly trust the contractor, or rather it's a check and balance mechanism by which there's a representative from the principal employer also who would be there to ensure that the wages are paid according to the accepted terms. Now, the question I asked, what if the contractor fails to make timely payment? The principal employer is liable to pay the full wages. Let's say the contractor is only paying a fraction of the wage that has been agreed upon. Again, principal employer is liable to pay the remaining fraction which the contractor is not paying. But again, like in last slide we have discussed, the principal employer can recover the amount from the contractor. So it's always a great idea that you don't pay the entire amount upfront to the contractor, and you keep a balance to ensure that all the compliance is met in terms of payment of wages or ensuring social security provisions. And then at the end, after all those things are taken care of, you pay the final installment of the money that you have to pay for the contractor. Now, who maintains register and records? Both the principal employer as well as the contractor should maintain registers. And in that register, there should be name of the contract worker, nature of the work that they are performing, rate of the wage that has been paid, any other details that is required in terms of their work. All those things has to be mentioned in the register. Now, additionally, the principal employer and the contractor is required to display notices in the prescribed form within the establishment premises where the contract labor is employed. So, if you remember the discussions around Standing Orders Act, it clearly says that all the rules and regulations has to be displayed publicly so that the workers can see it. But that was for workers. Contract workers also, CLRA Act specifically says that they are supposed to keep a notice board where all the details regarding wages and the details are exhibited. So it's a like-to-like version of what the standing order says. So hours of work, nature of duty, wage in terms of if you have category and all, not that extent, but in terms of what the workplace expect has to be provided. Now, going forward, we'll see an act called as Employee Compensation Act, which says that if an industrial accident happens within the workplace, who will pay the compensation and how the compensation has to be paid. Now, it gets more trickier when it is contract worker. So, who will pay the compensation? Is it the contract worker because he is the employer, or the principal employer because the money initially is coming from the principal employer? That's an interesting question to ask. So, let's say the work in which the contract worker was involved is a regular part of the principal employer's business. Then the principal employer is responsible for compensating any contract labor who was involved in the work. So, make no mistake, if the accident happened while the worker was indulging in the regular part of principal employer's work, then the principal employer has to pay the money. If the accident happens somewhere other than the premises where the principal employer usually carries out the work or has control over it, the contractor is liable. So going forward, while we discuss the Employee Compensation Act, we'll see that the premise becomes a very important factor in determining who is liable. So same logic is applied here. So the premise and the nature of work was a regular part of principal employer's business, so principal employer is liable. But if it is outside the premise and not the regular part of the work, or the principal employer has no control over what the person was saying, then the contractor is liable. With that, let me wind up this week. This week was pretty hectic. We had discussed the entire wage related stuffs. So if you remember, in the first two sessions we were looking at wage, how to calculate wage, how to pay wage, everything and anything that is related to wage we have discussed. After that, we have gone on to look at contract labor and then who pays wage to them, what are the obligations of employers. So I have expanded the scope of last two sessions much beyond than wage, because I wanted to cover the entire CLRA Act also. So we covered a little more than wage, but of course it comes under the broader umbrella of wages. With this idea, with this information, I'm sure now you are competent and confident enough to understand various wage components. Somebody walks in, you should be aware that what are the various legal components that it should involve. It should have a basic, it should have a HRA, it should have variable components like provident fund, which we have not discussed. We will discuss it going forward. And we have looked at bonus, which becomes a component in wage, how the bonus act speaks about its calculation, how it is determined, all those things. And then in the last two classes, we have looked at the entire concept of contract labor, how various definitions are there in the Contract Labor Act, as well as how the payment of wages, the Contract Labor Act, and ensuring various social security provisions happen. So we have discussed all that in detail. I think now is the time to make the big jump, where we will look into discussions on various social security provisions. So next 2 weeks we are going to dedicate to various social security provisions. So thank you for your patient listening, and let's join back next week to understand and explore various concepts related to social security and various laws that govern the social security aspects at workplaces in India. With that note, let me conclude. Thank you so much for your support and keep watching the course. Thank you so much.